move on to capital acquisition. And I went back, if you may remember these examples, and at the end I had, then comes a mammoth due diligence request. Okay, if you're seeking investment from private equity, venture capital firms, or strategic partners who just may be other corporations, you will get a mammoth, and I mean an intense due diligence request. And you need to be ready for it. The best way to be ready for that is to start to establish these practices that we've talked about now. So this is, don't try to read this, but this is an example of an IP due diligence request that a client of mine received from a private equity firm. You know, A through H, a list of all IP rights owned by the business, any agreements, licenses. I mean, there's a lot of stuff here. But, you know, what if you don't have anything to put on the list? It's kind of anticlimactic for a due diligence investigation. This one is very interesting. A checklist with attachments summarizing and documenting that each issued and pending patent has assignments from the inventors. You just want to be able to check that list off. It's just, you don't want to create an issue, so we get these things in place. I want to know all persons who participate in the development or maintenance of products and businesses. Why do they ask that? Well, if somebody contributed to the business and you haven't put in their assignment agreement somewhere in the data room, you're going to be asked why. Where is the agreement? Okay. Really important here. A listing of all previously prepared non-infringement, infringement opinions, including disclosure of any oral opinions. This is the freedom to operate studies that we talked about. They want to know if you've done it. Okay, they're not asking for them, that's an important thing, just that you've done it. Now, let me just summarize, in my mind, all of this really boils down to two questions. Okay, is the technology covered? And I think about that in a broad sense. Do you have IP protection for your products or services? All right, and then what are third-party IP risks? Now think about ownership and freedom to operate issues in this context. If you don't own the copyrights, you have risks. Okay, you have third-party IP risks. Somebody could sue you for copyright infringement if you don't own the copyrights. And what is the plan to address those risks? Now I would say question one is really, in my mind, people are interested in the technology, but the question really is your revenue model protected? Meaning, if my patents cover the technology that NewCo has developed, and those patents cover what I'm shipping to my retailer or distributor, therefore, my patents are protecting my revenue model, because now I can go exclude third parties from generating their own revenue from copying my work. Okay, so is technology covered? To me, is really about protecting your revenue model. That's what your investors are going to want to see. In addition to your business plan, the IP should match up to that in at least a logical way. So do the patents cover what the target is going to sell? That's the question I'll get asked. Now, are there any third-party IP risks? This is where your freedom to operate studies come into play. If your company sells a product, would that product infringe a valid third-party IP right? It's the same analysis we've talked about earlier in avoiding IP infringement risk. Investors want to know if you've done this. And if the answer is no, that's not necessarily the end of the day, but wouldn't it be nice to not have to address an issue in the face of a significant transaction where you're going to be infused with a lot of capital? You know, this is, I don't want to say it's easy to do, but it can be done. And the idea is more to have a plan. Are they buying a patent infringement lawsuit? I mean, this is really gets to the heart of the matter, or a copyright infringement lawsuit. So let's look at a couple of scenarios where we would ask these two basic questions. And And when I'm hired by a venture capital firm or private equity, this is what they're asking me. Does the IP cover the technology, and is there third-party IP risk? And I have to make an assessment. I have to give a definite recommendation. Scenario one, yes, patents cover the technology and the revenue models, reasonably well. We can make that assessment. Is there third-party IP risk? Low to moderate risk, but adequate plans in place. An FTO study was completed. All right. I'm not necessarily looking at the merits of the FTO study, but number one, that you've done it, and number two, that if there is an infringement risk, did you continue and do the validity study? Or do you have some reasonable design around in place that addresses it? There is no zero risk position in business in any context. You'll hear that from others, not just the IP attorney. And so my assessment of looking at an investment, low to moderate risk, that's a pretty good recommendation. I'll never say it's zero risk. You don't know. There could be patents out there you didn't see. Does the transaction close? Most often in these cases. Are there other factors at play in closing a significant investment? Absolutely. This is not everything. But if the due diligence counsel can make these recommendations to the investor, it just removes those issues. You don't have to deal with them in those negotiations. And you're really talking about whatever the deal is, a stock price, an asset purchase, and those terms. Those are the real terms that you really want to be spending your time on. Okay, scenario two, does the IP cover the technology? Limited protection or none. Maybe we have our IP assignments in place, we have copyrights, but we haven't filed any patents. But there's low to moderate risk, but adequate plans in place. FTO study completed. Sort of a mixed bag. We'd like to see patents covering the technology. My guess is in the midst of that negotiation, and what I would recommend to the private equity firm is when you close, they need to have a plan in place to address this. Okay, maybe that's enough to get the investor over the hump. Maybe there's other issues that come into play, but this is a doable thing. Okay, when you're at the stage where you're attracting $2.5 to $5 or $10 million of investment. Scenario three. This is really where you don't want to be. Okay, limited patent protection. You didn't do an FTO. It's a crowded, competitive field. Just wasn't a lot of thought done onto the risk position. Okay, so looking at these three scenarios, this is generally where transactions tend to close more in this side than they do over here. Is it because of the patents themselves? Maybe not, but this is also indicative of maybe inadequate planning in other areas as well. Now, maybe there's a limited budget here. That part of that comes out in the due diligence. Okay, and that's perfectly reasonable. But generally, if you're at a spot where you have protection and you've mitigated risk, you're in a better position to close on a capital transaction. Okay. Now we went through that really quickly, and this is all I had for part three. We've got a lot of time for questions. I'll open it up. We can go from there. Yep.
We've been talking about the PCT. How much does that affect investors?
Okay. The question was, Rich and I have been talking about international patent protection recently, and how does international patent protection affect investors? It depends on the business. For medical device companies, foreign protection is pretty important. The question always comes, where are the U.S. patents and where is your geographic coverage? I have a client right now that was purchased by a large medical device company, and they are extending patent coverage post-closing because they have businesses in places that my client at the time I started working with them wasn't really interested in. So it's a factor, it's important. It's not it's not the deciding point. I mean, certainly you don't want to not pursue, I think, U.S. protection. But foreign patent protection is helpful. Depending on where you are, the international patent application can buy you some time. And then the investor can make decisions after the fact. Okay, so that's one. Any other questions? No? Yep.
At what point are you paying the patent office to process your patent throughout this?
Okay. I'm going to repeat it just for the video. The question was, what point are you paying for the patent office to process your patent? Early on in what I call patent development stage, there's initially patent preparation and filing, and then you file the patent application and prosecute that to issuance. That's the stage where you're developing the patents, so to speak. So it's early on. That being said, if in cases where you're seeking investment, that process doesn't necessarily end. Like on day one of your business, you may have patent A, but then you have modifications or changes. You may file another patent. So it could be ongoing as you're entering this transaction, but it certainly starts early on. Yep. Any other questions? Nope. Yep.
What right do we have on scenario 2? What right do we have to stop somebody from copying what you've done?
Yep. I'm going to repeat it again. So the question was, in scenario 2, what right does the company have to stop a competitor from doing something? And it's a simple question, a simple answer. You don't. And that's the problem that the investors see, is that you don't have the protection in place to stop potential competitors.